Okay, it's just after 6 o'clock. I realise some people may still join, but I think that we've got a decent chunk of people already joining. So it's my pleasure to welcome you all to this evening's webinar, presented by two members of the Court of Protection team here at Garden Court Chambers. My name is Helen Curtis. I'm a member of the team and I'm chairing the webinar this evening. And I'm delighted to say that we have Tim Baldwin and Felicity Williams, who will both be sharing their expertise with you this evening. The webinar is in two parts. I'll come on to the detail of it in a moment. But just so you know, it is being recorded, and that means that it's going to be available subsequently for those who aren't able to join live this evening. And the slides and the recording will be made available later this week. I'm sure you're all well aware of the format of these things. There is a Q&A function which is available, as well as a chat function. So please, any questions, pop them in the Q&A box. If you have any observations or comments that you want to make which aren't for the panel, then there is a chat function. So I'm sorry that we can't see you all and welcome you into air-conditioned rooms with refreshments later, but we'll have to just imagine those. So the substance of this evening's webinar is, as you know, about the issue which is central to the Court of Protection, and that's capacity. And so, as I say, it'll be split into two sections. We'll have Tim Baldwin first speaking about the practicalities broadly. Tim, as you know, very experienced, committed to representing those who are vulnerable, marginalised in not just the Court of Protection, but also in the mental health sphere. He deals with health and welfare decisions, as well as specialist accommodation and deprivation of liberty issues, accepting instructions across a range of client base, including the official solicitor. So I'm going to invite Tim to start. I'll be texting you a 5-minute warning, Tim, before introducing Felicity to you. So Tim, over to you, please. Thanks.
Okay, thank you, Helen. I'm going to try and share my slides. Can you see my slideshow?
I can see it says the end of the slideshow, so I think we're going to not do it first. We're starting at the beginning. Fantastic.
There we go. So what I'm going to deal with is sort of go back to what you might call the basics in terms of looking at resolving disputes in respect of people's capacity to make decisions or refuse or not agree to particular steps, either in their care or accommodation, or any issue really that requires them to be able to make a relevant decision. And I'm going to break this down into what I call a back to basics type of look at capacity disputes and resolution of these. And also this will be looking at it in the context of the recent letter, joint letter from the former Vice President, Mr. Justice Heyman, in collaboration with Senior Judge Hilda in respect of the use of Section 49 reports. So that will come up as a central issue. So one thing always to think about in court of protection cases, and in other cases involving concerns about a person's capacity, is to actually, first of all, identify whether there is really a dispute about a person's capacity to make a particular decision. And also, if there is, on what particular issue that there is that dispute about. Because I've often been in some court of protection cases where it's almost become a matter of just routine practice to go down a route of seeking either a further report on capacity or a report on capacity that's very general, and not focusing on the relevant decision that the person has to make, or the issue of concern. So you sometimes can have quite unfocused report. And really people have to direct their minds to whether there is really a dispute about someone's capacity, so that you don't expand the litigation beyond that which really addresses the issues at hand. And I'm going to briefly remind you of the statutory framework, which is a founding of how to assess capacity, and the code of practice. One of the matters that comes up, which Felicity is going to address you on more than me, is the issue of fluctuating or longitudinal capacity, and how this is dealt with within court of protection proceedings. Felicity will focus on that, but I'll touch on it very briefly, because it's something that's not really dealt with within the legislation or the code of practice. Then I'll go on to looking at rules on instruction of experts, and a way forward and practical considerations. And I don't know why this fluctuating or longitudinal capacity bullet point has come up again on my slide. Obviously, I suffered from some fluctuating or longitudinal capacity issue when putting these slides together. So going back to basics, and one should always start, and I always start, with looking at the issue of what are the fundamental principles, and these apply for the purpose of the Act, and also to engage the jurisdiction of the Court of Protection, and it's such that it must be ingrained in everyone's soul and inform everyone's decision in litigation. Is the person who's subject to the litigation is the most important person in the litigation or the dispute, and they always must be assumed to have capacity, or unless it's established that they lack capacity to make the decisions. And one of the important things that is often missed, particularly in securing reports or looking at capacity assessments, is a person is not to be treated as unable to make a decision unless all practical steps are taken to enable them to make a decision. And it demonstrated that these are without success. I'll turn to that a little later on, but one of the things that is something that should always be considered within assessments of capacity is what support people need, what circumstances an assessment is carried out in, and whether a simple review of someone's medication regime should always be taken, given that, for example, if someone has some form of schizoid or other disorder, whether changes in their medication or review of their medication or trials of their medication is something that ought to be considered, because the Mental Capacity Act is not just there as a protective act. It's not there just to protect someone who lacks capacity, but it's also there to try and further and promote their autonomy and enable them to make decisions. And it always has to be considered that a person is not to be treated as unable to make a decision just because they make, from a different person's perspective, an unwise one. And it always must be under 1.6, before an act is done or a decision made, regard must be had to whether what is needed, whether they can effectively deal with these matters in a less restrictive manner to promote the rights and freedom of action of the individual. So those principles inform everything, and particularly in terms of people who lack capacity. And one of the things is that it always has to be that it's considered, it always has to be assessed in respect of the material time. So when somebody is making that decision, and it also has to relate to an impairment or disturbance in the functioning or mind or brain. And it has to be in relation to a particular decision. One of the things that has come out in the case law, and Mr. Justice Hayden said that you don't need a particular diagnosis of a mental disorder to engage the notion of a disturbance in the functioning of the mind or brain. Now that's correct in respect of how the statute is formulated, but if someone does have a disturbance in the functioning of the mind or brain, it might be a good idea to try and get a clear diagnosis and a clear prognosis in respect of that disorder. The reason being, often in cases such as fluctuating or longitudinal capacity, you may be dealing with somebody who has a personality disorder or an unstable personality disorder, or a mental disorder that's obscure or treatment resistant. And one has to take a step of examining whether medical treatment and a proper examination and diagnosis of that disorder and its prognosis will enable that person to make capacitous decisions if treated properly. And it's often a key when you do the assessment, at what material time do you do that assessment, because it doesn't matter whether the impairment or disturbance is permanent or temporary. And that means that you may have to do several forms of several capacity assessments at different times. And you can see that in the rest of this section, it identifies when capacity cannot be established by mere reference to certain characteristics. And it identifies that the act is by reference to person, not reference to persons under 16. So what we have is a situation where it has to be established whether a person is unable to make a decision for themselves. And the particular identifying statutory characteristics are identified under section 3(1) through D, which you're all familiar with. And in particular, 1D is important because as part of this assessment, people must be given some assistance in respect of the communication of that decision. It cannot merely be that just because they can't communicate it effectively, that that is something that they don't require assistance with. And they must be looking at consideration of the relevant information. And so it has to be put to them in a manner what decision and on what documents or what type of decision they're being asked to make a decision on. And it must be using different mechanisms of assistance. So those are the key things to look at. And so if you are in a dispute as to capacity, on what issues do the disputes arise, and what expertise do you need? Sorry, I keep getting a bunch of pop-ups coming up which cover up the slide, and so you really need to know what expertise you need, and is it available to resolve any dispute on capacity. For example, the Court of Protection rules, particularly Part 14 of the rules and Practice Direction 14E, provide for how you go about selecting an expert under Section 49 of the Act, that is effectively the court visitor provisions. That is the classical route that you get into getting expert evidence to enable the Court of Protection to help you resolve disputes on particular issues. However, that doesn't preclude the use of independent experts, and independent experts with particular expertise, which does not exist, say, in a local trust, or that local trust does not have someone with sufficient experience, or that they really cannot answer the particular issue that you're requiring expert evidence or an opinion on whether a person has capacity to make that relevant decision. The Code of Practice, particularly Chapter 4, is helpful in looking at ways through getting the appropriate evidence and the particular circumstances to deal with such matters. But recently, a letter came, and the link is there, from the Mr. Justice Hayden in collaboration with Her Honour Judge Hilda. And basically the letter says that there's a lot of concern expressed about the scope and ambit of Section 49 reports. And there was a strong feeling that some of the Section 49 requests are disproportionate, overly burdensome, and wrongly authorised. And they say there are obvious reasons why a Section 49 report might be preferred, where what is truly required is an independent expert report. Now, I'm going to point to the rules, the procedural rules in a moment, to say how this letter may be driving those representing people in capacity disputes more to securing independent experts against the thrust of the rules. And this letter goes on to say that Section 49 reports are paradigmatically appropriate where the NHS body, typically a mental health trust, has a patient within their care is known to them. And this says this ought to enable a clinician to draw quickly on his knowledge of the patient and respond concisely to identified questions. And there's a reference to the practice direction. And it says instructions under Section 49 should be clearly focused with tight identification of the issues. Report should be concise and not require extensive analysis across a wider range of questions than those contemplated by the practice direction. And it said reports requiring that kind of response should be addressed to an independent expert. So we all know that it's almost impossible in some areas to get a Section 49 report within a reasonable period of time, particularly the 8 weeks, which is normally identified. But my view is this letter kind of is pushing people to say, well, you get Section 49 reports in relatively simple and straightforward cases within the ambit of the practice direction. But when you don't meet that, what you should be doing is going down the independent expert reports. And the way to deal with this is looking at the relevant rule. and the rule is under the Court Protection Rules, Part 15. And the overriding objective and the of the overriding objective under the rules is key, in my view, and also to ensure the participation of P. But there's clearly within the rules a duty to restrict expert evidence. And one of the key things is that it says it shall be restricted that which is necessary to assist the court resolve the issues in the proceedings. And you must get permission for it, and you must overcome a couple of hurdles. And one of them it is necessary to assist the court resolve the issues in the proceedings, and it cannot be otherwise provided by Rule 1.2 representative or in a report under Section 49 of the Act. So there's a requirement to consider Section 49, but in my view, the letter from the previous Vice President and the senior judge gives you an indication as to how you can overcome that hurdle and whether a Section 49 report is really appropriate. And if you go into getting an independent expert report, you do have to meet the rules in the consideration in Rule 15.5 and the relevant practice direction. And that's all set out there, and it's quite onerous. But in summary, you have to think practically in terms of whether there's a dispute, how you identify it at a particular time, whether you can resolve issues of capacity through medical treatment, and whether, if you can't, the type of report and the type of expert you require. So I'm going to turn over now to Felicity to give you all the exciting stuff after the boring stuff I've talked about.
Thanks very much, Tim. Boring is your word, no one else's. Thank you very much for that. Useful ways to remember, of course, useful reminders to check that the trust has got the relevant expertise that you need, as you've said, and also whether or not there are conditions which can be treated for P, which would really go into the equation of whether or not P can regain capacity. All useful pointers to remind us. I'm going to turn now to Felicity, who a member of the Court of Protection and Community Care team here at Garden Court Chambers, specialising in public law, particular expertise in representing young as well as vulnerable people, and involved in cases not just with deprivation of liberty issues, but some significant personal welfare applications and complex care packages. So I'm going to, in the interest of time, go straight over to you, Felicity. I think you're going to take us on a bit of a journey through some of the recent cases and look at how the courts are managing to try and resolve some of the issues which Tim has alluded to. Thanks very much.
Thank you, Helen. I'll just share the slides on my screen.
The journey is always a bit difficult to start with. Are the slides visible to you?
Not currently. Okay. Helen, I may need you to...
There we go.
Take over.
I think that Amy in the background has done a wonderful job, and these are your slides.
Thank you very much. Apologies for that. So yeah, if we could move to the first slide then. Thank you, Amy. Okay, so in this session, I'm going to try and address a little bit how expert evidence on capacity is applying in practice, and address some of the points that Tim has referred to in the light of the cases that are currently ongoing and have been under consideration recently by the Court of Protection. Some of the issues recently highlighted have included fluctuating capacity, autonomy, the actual boundaries of the Mental Capacity Act regime, and the scope of relevant information for the purposes of Section 3. Thank you. If we could have the next slide. So turning to the first case we're going to consider, that is the case of PG and a local authority. I'm going to run through these cases in hopefully Eurovision style, swiftly moving from one to the next. So you may see a bit of a theme through my slides. This case concerned issues about determining capacity in relation to care and contact, and the correct form of declaration to be made by the court. It was a finely balanced decision on capacity and demonstrated the uncertain boundaries between diagnosis and presentation. PG exhibited fluctuating capacity, and Mrs. Justice Leven was very clear that that created some novel difficulties. And you can see from the quote there that she said that the law's desire to have clear lines as to both what decisions she does and does not have capacity to make, and in what circumstances she loses capacity, does not fit with the reality of PG's presentation. So that may be a quote that sounds familiar to many of you in the cases that you're dealing with, where capacity is unclear and doesn't fit into the neat boundaries that the law would like us to be considering. So how did the court deal with this? Amy, if you could turn to the next slide, please. So PG was a 34-year-old woman. Her diagnosis was one of intellectual disability, autistic spectrum disorder, emotionally unstable personality disorder, and a mild learning disability. She displayed unsafe and dysregulated behaviour in the community, and she'd reportedly been found frequently intoxicated, approaching young men, asking members of the public to kiss her. She'd climbed into cars belonging to strangers. There'd been incidents of self-harm and suicidal ideation. And her dysregulated behaviour was also seen within the placement, where she exhibited for verbal and physical abuse towards staff. There'd been property damage, refusal of support, and absconding. There were a variety of triggers to that behaviour, and this included sirens, increased alcohol consumption, stress around court hearings, her menstrual cycle, changes of residence, and police involvement. So the expert evidence in the case really highlighted the complexity of what the court had to deal with. In the reports that the expert had given, he assessed PG to have capacity in relation to contact. In relation to care and support, it was more equivocal. PG lacked capacity in the community because of her attention deficits and/or heightened anxiety, which he attributed to her intellectual disability and autism. When the expert gave evidence, live evidence, he stated that PG would struggle to weigh and understand information when dysregulated, but not when calm. And in the community, it was hard to disentangle the influence of alcohol on PG from the issues concerning her mental capacity. And just to show how finely balanced the circumstances were, the expert also referred to the fact that you wouldn't actually be able to determine what was the primary influencing factor unless you were able to speak to PG at the time that she was making the decision. So it was a very difficult situation to gauge in terms of the evidence. Mrs. Justice Leven identified the challenges that she was facing, and she said that the evidence suggested that P sometimes had capacity and sometimes not. There was a close correlation between when P might lack capacity and the making of unwise decisions. And there was a correlation between unwise decisions and being intoxicated. So there were a correlation of things that were causing difficulty in the case. Thank you. So there were two approaches that the court had open to consider in this case as to how to deal with these capacity issues. Approach number one was the longitudinal approach that Tim has already referred to, and that's the approach taken from the case of Cheshire West and PWK. In that case, P at times became overwhelmed by anxiety, and the court took a longitudinal view of how to address that. It was noted that the case law as to which approach to be taken drew a distinction between those cases where there were isolated decisions to be taken and those where there were decisions to be made regularly or repeatedly and sometimes at short notice. There was also reference to the case of Greenwich and CDM, and that was another case where there was a macro decision or a series of micro decisions about diabetes management. But overall, a longitudinal approach was needed because of the repeated nature of decisions being made. So the second form of approach, thank you, Amy, was that of anticipatory declarations. The case of Wakefield and MDC and DN dealt with this. In that case, DN had a severe form of autistic spectrum disorder and a general anxiety disorder. DN was assessed to generally have capacity, but when he had meltdowns, he became highly dysregulated and lost capacity. And the approach in that case was slightly different to the one in the first approach. The judge observed, it seems to me that the outcome of an anticipatory declaration would provide a proper legal framework to the care team, ensuring that any temporary periods of deprivation of liberty are duly authorised. In that case, the order was made declaring DN had capacity, except when presenting in a state of heightened arousal and anxiety. And at those times, care and treatment was to be delivered in accordance with an annexed care plan. So in that case, on approach 2, we have situations arising that are sufficiently distinct for an anticipatory declaration to work in practice. So what did the judge decide to do in the case of PG? Well, considering the two approaches, the judge didn't think that one or other was indeed a better approach. So what did she decide would dictate the approach taken? Well, she said how an individual P's capacity is analysed will turn on their presentation and how the loss of capacity arises, so the triggers that we looked at earlier in this discussion, and how it manifests itself. Both the decisions in issue here are ones that arise on a regular basis and often not in a planned or controlled situation. Regard was to be had to the importance of making orders that are workable and reflect the reality of PG's lived experience for the sake of PG and those caring for her. So what's required in these cases is a very close analysis of the individual circumstances and also a pragmatic approach as to what is going to function and work in practice. So the decision of the court was that PG lacked capacity in relation to care. She also lacked capacity in relation to contact. And that was, the judge felt, evidenced by her frequent approaches to strange men as attempts to get in their car, that she was clearly unable in those situations. She was not weighing the information available to her. The primary cause of her lack of capacity was mental impairment, although the court did recognise that, of course, alcohol played a part. So the appropriate approach, the judge ruled, is to take the longitudinal view. An anticipatory order would in practice be close to impossible for care workers to operate and would relate poorly to how her capacity fluctuates. The care workers would have to exercise a complicated decision-making process in order to decide whether at any individual moment PG did or did not have capacity. And she felt that the more practical and realistic approach is to make the declaration that PG lacks capacity in the two key respects, but also to make clear that when being helped by the care workers, they should, as far as possible, protect her autonomy and interfere to the minimum degree necessary to keep her safe. So just pausing there on that last part of the quote, there was a very pragmatic view taken that the legislation had to be treated in an effective way, and that there was a balance here between making a decision on capacity and also ensuring that autonomy was protected via the plans in place for the care workers. So it is a difficult decision because on the one hand, we see a practical approach being taken, On the other hand, the actual decision making, to take that broad brush longitudinal approach, could be seen as quite restrictive, and also obviously a very careful decision to be made then by the care team on a day-to-day basis. So some difficult ways to answer these questions, and the court has continued to grapple with that. Thank you, Amy. So the approach taken in cases of capacity will be case specific, and analysis is critical, as we've just seen. Practical issues will include the background to the matter, how long things have been, how long the presentation has been as it is, as Tim said, whether the matters might resolve in future, questions of diagnosis, which in PG was obviously complicated by the alcohol consumption issue. Relevant information to be considered is obviously really critical, and as is the form of decisions and regularity of those decisions. And workable solutions that also protect the autonomy of P are going to be critical. Thank you. So the next case we're going to look at is one, again, focused on autonomy, and that was the case of a local authority and H. And this is hopefully a useful case to everyone attending, because the judge grappled with dealing very broadly with the capacity issues. So P was described as having very complex psychological and psychiatric challenges, and that included global developmental delay, ADHD, executive dysfunction, developmental trauma disorder, and possible emotionally unstable personality disorder. As in the last case, when dysregulated, H's behaviour could present as a risk of harm to herself and others. And the court was asked to consider H's capacity in relation to residence, care support, contact with others, and the use of internet and social media. The expert evidence was that H lacked capacity in the relevant domains, and the court's judgment accorded with that view. Mr. Justice Hayden, giving the judgment, set out to put the relevant law in relation to capacity issues in one accessible judgment. So obviously I would encourage you to look at the judgment. I haven't set out every aspect, but it is very helpful in giving a run through of all the relevant issues relating to capacity. He wished P herself to see the effort and care that had been taken for her by all the professionals to respect her autonomy as an individual. Thank you, Amy. So first of all, the court looked at the basic principles of the MCA, those matters that Tim has spoken to us already about this evening, the diagnostic test, the functional test, and the need for a causal connection between them. It was careful to, in this judgment, the court was careful to emphasize that the question of causation should only be considered if the functional inability to make the decision has been established. An assessor of capacity in the court must ask as a preliminary matter, what is the decision to be made and what is the information relevant to that decision? So again, harking back to the points that Tim made earlier in this seminar, really looking right from the outset as setting this question up correctly. What is the question that the court's being asked to answer, and what information is going to be required to do that? Mr. Justice Hayden emphasised that the relevant information must be set within the specific factual context of the case, and the assessment must be unique to P and to P's specific circumstances. Core to the assessment is the protection of individual autonomy, which demands a highly fact-specific approach, and the relevant information which informs the decision will be both fact and person-specific. Finally, as to whether P has capacity to make a specific decision at the material time, if there is evidence of fluctuating capacity, that will be an appropriate qualification to the assessment. And again, this is something that Tim's referred to and is addressing very pragmatically how we achieve the best results for individuals who are before the court of protection and may be assessed to lack capacity. That question of timing and how we how we address that is really critical, and something that we'll see has been addressed again by the court quite recently. Thank you, Amy. So the core message emphasised very strongly in this judgment was the danger of elevating the instinctive need to protect a vulnerable adult to such a degree that it corrupts the integrity of an objective assessment of capacity is an ever-present danger in this sphere of work and requires vigorously to be guarded against. Paternalism has no place. Protection of individual autonomy is the magnetic north of this court. So if ever we needed reminding, that's a very clear emphasis being placed there. It's interesting, that balance that's being struck and that we're being reminded of throughout these cases, because as I just noted in PG, that longitudinal approach could be misinterpreted potentially, where there is too much emphasis placed on the need to protect a vulnerable adult and not enough thought given to autonomy. So there's that reminder actually rings very clear throughout this entire line of recent case law and the guidance that we've been discussing. So practical application, a merely technical approach to identifying decisions and relevant information is not going to be sufficient. And the court in this case was careful to emphasize that some historic case law may not be adequate on this point, because what tends to happen is that we look back at those older cases and look at a list of things in each domain in terms of relevant information that we might want to put to an expert. What this more recent case law is very clear to emphasize is that we have to go and look at the individual and what information is going to be relevant for them, what is their situation, and that's going to have to be thought about, I think, a lot more clearly going forward, and obviously something that everyone's going to be considering when drafting letters of instruction and considering appropriate experts and so forth. So front loading the cases here and very much tailoring them to the individual who we're considering. Relevant information is to be decision and person specific, and as I've just emphasised, is that important point of autonomy versus the protection of vulnerable adults. Thank you, Amy. So rattling on through our cases here, and I've put my Eurovision reminder at the top here to get on with it. Recent case law has also considered the boundaries of the Mental Capacity Act, and an interesting case that was heard at the end of last year was the DY and A City Council case, which addressed the issue of criminal justice and capacity issues. DY was a young man in his 20s. He had a diagnosis of ASD, generalized anxiety disorder, and paedophilia. And in 2016, he'd been detained under the Mental Health Act. Subsequently, in 2017, he was determined to lack capacity in relation to his detention and treatment under the MCA, and he was moved to a specialist placement. In 2017, he was convicted of 2 offences of sexual assault on a girl under 13 and placed on the sex offenders register and referred to MAPA. He was subject to, or made subject to, a sexual harm prevention order that was still in place at the time the court came to consider this case. DY moved to a further placement in 2019, and he continued to be assessed as unable to make decisions about accommodation and care, and he continued to be deprived of his liberty subject to a standard authorization. Thank you. So the issues in the case were, firstly, was the primary focus of the care plan to avoid harm to DY for the purposes of the best interests qualifying requirement? Well, the court's answer was yes, they were satisfied that the purpose was to avoid harm to him, and I don't intend to address that further because we're concentrating on capacity. The second issue for the court was whether DY had capacity to consent to his care and support arrangements. And again, the court found that he did. So the case had evidence from both the local authority and also from local authority social worker, an assessor, and also from the expert consultant psychiatrist. The psychiatrist considered that DY's ASD, which included anxiety, was the relevant condition for the diagnostic test. And the judge noticed that the expert evidence included that DY was able to set out a level of care, with a level of care that he believed would be both sufficient, beneficial, and would balance his own wishes for a greater degree of autonomy and independence with an umbrella of oversight and protection. So DY quite clearly had an insight into what was needed in the circumstances of his case in terms of his care planning. And he was actually presenting in quite a insightful way in relation to that. The expert was of the view that any further offending should be viewed within the remit of the criminal justice system, and that was consistent with his current SHPO. Thank you, Amy. So the judge preferred the evidence of the psychiatrist. She noted that the respondent's experts had relied heavily on the fact that DY had made contradictory statements and failed to think through things and could overestimate his ability. And she noticed and observed that in doing these things, DY was no different from many people who do have capacity. People with capacity can make unwise decisions and act on impulse. And she concluded, I entirely understand why the respondents in this case are so concerned, because there is a high risk that DY will re-offend. But Dr. Ince is right that any further offending is a matter for the criminal justice system. The current SHPO is an example of such risk management. The truth is that most sexual offenders and risky adults have capacity, and like DY, are not to be managed by a deprivation of liberty within the provisions of the Mental Capacity Act 2005. So quite a firm pushback by the court there. Thank you, Amy. So observations in this case were that the expert questions appeared to have been very well identified and the context of the decision-making thoroughly considered. It was a very person-specific approach. P had been given an opportunity to address very directly the concerns before the court. A balance for his autonomy had been sought, and also pragmatically, again, the public protection issue squarely addressed. So moving finally to my last case here. So a final case re-emphasising the tailored approach is Gloucestershire County Council and AB. And appropriately, we're back to our host state because Garden Court were involved with this case and Tim Baldwin was representing the official solicitor in this case. So he can correct me as I present this. Was that not, he's going to correct me straight away, was involved. And yes.
I represent the Gloucestershire.
Oh, Gloucestershire. Okay, so there we go. Issues. P had a pattern of severe self-harm posing a potential risk to her life. The court had to consider best interests in relation to care and support arrangements and capacity and best interests in respect of internet and social media access. So fortunately, the parties were in agreement and the court were able to identify clearly the relevant information for the purposes of determining capacity. I'll let you look at those points, but it was very closely aligned, the relevant information, to the significant concerns that there were for AB and her self-harm presentation. Thank you, Amy. So on the basis of that framework of relevant information, the parties agreed and the court was satisfied that AB lacked capacity in relation to the internet and social media. However, no party sought for the court to make a final declaration as to AB's capacity to access the internet and social media, as expert queries were outstanding. And this is going back to Tim's point at the outset, because there was the prospect in this case that AB's medication might be optimized to support her to demonstrate capacity. And so the court didn't make any final declaration in relation to that. As a result of the finding that AB lacked capacity, her internet and social media access was to be restricted in accordance with a targeted plan. So again, we have well thought out relevant information, a person-specific approach, fluctuating capacity taken into account, and a very workable outcome from the court in terms of how to approach the case in future. Thank you very much.
Thanks very much, Felicity, for that journey through the interesting waters of capacity and how the courts are seeking to approach those rather challenging issues when they give rise to such complexities. There's not very many questions. I don't know if anyone has burning questions. I can reiterate that the slides are going to be circulated, as will a recording of this webinar, so everyone will be provided with that. I'm afraid the panelists can't respond to individual cases and give specific legal advice. We can make some general observations in terms of obtaining capacity assessments. I appreciate that that's obviously a time commitment from any clinician who's invited to do that. And some people have to be imaginative as to who they ask to obtain capacity assessments. But I'm afraid I can't give any specific advice as to who to approach. If there's a refusal by one, then obviously if capacity needs to be determined and there's a dispute about it, then a different clinician will have to be approached. I think that I don't know whether or not there's anything else, Tim or Felicity, that you want to add, just reflecting on having heard each other speak about the difficulties, some of the practicalities. I remember the case about this specifically. It was a permission to appeal case about obtaining a Section 49 report where a trust had refused. And I think that was just on a practical point, because it was in front of Mr. Justice Hayden, who really reiterated and endorsed the court's discretion on obtaining a Section 49 report, provided that at least the trust had some knowledge of P. So I think in that case, the trust had tried to appeal the case management decision of the lower court and say, we're entitled to refuse to do this Section 49 report. And Mr. Justice Hayden refused permission to appeal the case management decision. So there is, given that he was the one who sent the letter in conjunction with Her Honour Judge Hilda, some reassurance that the door hasn't been completely closed on obtaining Section 49 reports. And where there's any suggestion that P has been open to one or other trust in the past, then there is room to go back to that trust and push a little bit to see whether or not they're willing to provide a report. I don't know if Tim or Felicity, you have any comments about that?
No, not on that issue. I was reflecting when Tim was speaking about the importance of prognosis, that future-looking aspect, you know, to get that addressed and thought about early is obviously helpful, because I've had cases where we've had to go back and find out more details. So I think that idea that you get, you know, medication review resolved and consider the future trajectory of someone's presentation is a really important matter to take into account.
Yeah.
Really, because I've noticed that a number of the cases that Felicity looked at, a number of cases that she been for the courts, relate to sort of dysregulated behaviour, and sometimes that's something that's difficult to characterise in terms of a diagnosis and also a legal test. What is dysregulation? And it's couched in the context of a diagnosis of an unstable, emotionally unstable personality disorder. Now, that diagnosis is only available under NICE guidelines and under ICD-10, which has been replaced by ICD-11, when someone turns 18. But one of the problems is that the Mental Capacity Act applies to people from the age of 16 onwards. So we were all teenagers once, and teenagers, can display personality disorders and then sort of grow out of them, as it were. And it's very difficult, I think, in that transition from particularly people who have difficulty in childhood, early teenage years, and then developing into adulthood, to be properly diagnosed and their sort of what you might call their treatment pathway identified, particularly in some of the cases that Felicity has identified. So having those sort of what you might call pathway projections and possible diagnoses and prognoses is very important to people's care planning.
Absolutely, Tim. Thanks everyone for the questions that are coming into the Q&A, and thank you to those who are answering them, which is great. Effectively, we have a question about where a Section 49 capacity report is perceived by PEES representatives as not sufficient or not thorough enough. And that even further questions to its author wouldn't really get to where the report needed to be, but other parties are content with it. What are the options? And I think that it's a difficult one, but I think that if you can genuinely put, my view in anyway, subject to anything that Tim or Felicity want to say, would be that if you can genuinely point to where it is deficient, then it may be a matter for the court to either accept or reject. I have been in cases where the parties all think that the report might just be good enough, and the court has said it isn't. And that can be a way through. So I would say stick to your reservations if you have them, and then invite the court to lend its weight to potentially getting an independent expert. I think that we can try and follow up, because I know we have to finish in a moment. We can try and follow up on some of these questions when we send out the slides and the recording, but an encouraging comment that some trusts, even when they have been directed to provide a Section 49 report, but didn't want to, the order then was obtained to instruct an independent expert, and then the NHS Trust paid for the cost of it, or presumably part of the cost of it. So that's encouraging. Increasingly, where there's ICBs in cases, there are discussions outside of the court proceedings in order that some financial arrangement is made so that those reports can be funded. I don't know, we're just at 7 o'clock. I don't know whether or not, yes, just very quickly, you do need the court's permission if you want to instruct an independent expert. You can't just go and get one. You need to apply to the court under Part 15 of the Court of Protection rules to obtain the court's permission to instruct an independent expert. I don't know whether or not Felicity or Tim, you can pick up on anything here, but I'm
reading them, but probably not quick enough to answer. I think, as you said, let's try and maybe add something to the slides when we circulate, and we'll try and pick up, because there's some themes coming through these questions. So that would be helpful to do.
Yeah. Okay. I think one that keeps cropping up is in relation to fluctuating capacity. So maybe that's something we can expand on when we circulate the slides.
Can I just ask, what is the question on fluctuating capacity? Basically, what is the thrust?
How do you ensure the assessment properly encapsulates their capacity? So if they have good and bad days, so we can answer that one quite quickly, because obviously it may be necessary for an expert to go back on more than one occasion. And in fact, that does happen in practice. where presentation may vary very widely from one day to the next. And of course, that's one of those cases where you would want to consider in advance, you know, before the expert goes and attends for the first time, is this somebody that's going to need more than one appointment, and how is that going to be achieved practically? So yeah, good question.
Okay, thanks very much, Felicity. I'm sorry to be wrapping this up. I'm grateful to everyone who's attended, obviously, and has shown a real interest in this very important area, and look forward to seeing many of you, hopefully in person, next time. We'll be doing some more webinars later in the year, and hope we'll be able to have a bit more of a social time afterwards, away from the screen. But for now, thanks very much both to Tim and Felicity, and thank you all for attending.
Thank you, Helen.
Thanks. Bye for now.